To my colleagues and to Dr. Weiss, who's with us, I'm Mary Zamor. I'm the Executive Director of the Women's Rabbinic Network. And welcome on behalf of WRN and especially of ARZA Rabbinic Council. I want to give some logistics about this webinar and then say a proper welcome. So I want to remind everyone that this is a call format, so meaning that everybody is active and live, and we can see and hear you. So please feel free to put yourself on mute. In fact, it's pretty imperative you do, so we'll hear well. Dr. Weiss is going to give her formal presentation with a rich PowerPoint that we'll be able to look at. And then there'll be ample time for questions and answers. You can use the chat feature of this Zoom presentation. And using chat, you can address those questions directly to Josh Weinberg. WRN is deeply grateful to ARZA, especially Rabbinic Council, for their leadership, and especially to Josh and Neil, who's helped organize today's call. And it is my pleasure to introduce Dr. Susan Weiss of Mirkaz Tzedek L'Nashim. We are so grateful for your time and for the work you do every single day. Susan is the founder and executive director of the Center for Women's Justice, and she's been working actively to find solutions for problems of Jewish women in divorce for over 20 years. First as a private attorney, then as the founder and director of Yad L'Isha from 1997 to 2004. And now as the founder and executive director of the Center for Women's Justice. She has had an auspicious career, especially one thing I'd like to particularly bring light to, her amazingly innovative tactic of securing compensatory damage awards for women whose husbands have withheld get by filing damage caused cases in the Israeli civil courts. And this tactic has been called game-changing. She has been awarded with many auspicious awards for her innovative and passionate work. She's a sought-after speaker and lecturer. And I want to mention that she holds an MA and a PhD in sociology and anthropology from Tel Aviv University and a JD from Brooklyn Law School. Dr. Weiss, we welcome you. We're so grateful for your work every day. We on this call know that to be a passionate Zionist is also to ask Israel to hold itself to a higher standard and to really expect the best out of the country we love. And we thank you for what you do every day to make that happen. Dr. Weiss.
Well, thank you very much for this opportunity. It's really very exciting for me, both from a technological standpoint, because it's the first time I've ever done something like this, and also to be able to tell all of you about the work that we're doing. And I feel that we really have partners in you in exactly the way that Rabbi Zamor expressed it, because it is out of love of the state of Israel and a deep desire to see it rise to the occasion that has been given it to be a state and to make it a better place for all of us. So the name of my talk today is Agunot, Adulteresses, Mamzerim, Women Who Want to Pray with Torah Scrolls and Other Good Reasons to Separate Religion and State in Israel. And I have two beginning theses for my talk. The first is that by adopting Din Torah, religious laws, as the laws of the state, as the laws of the land of the state of Israel, Israel infringes on the human rights of its citizens. And the second thesis is, by using different strategies, the Center for Women's Justice calls on the secular arm of the state to respond to these infringements that are exacted by its religious arm. And I'm sure that this will become more clear as I go further on with the lecture. So the outline of my talk is as follows. What we're going to do is really use 3 case studies of cases that were actually litigated in our office. But before I do that, I will give you some background about Israeli law and how it has adopted religious rules. And then we're going to have the case of the aguna and the homosexual husband, the case of the adulterous mamzer and the man with the tattoo, and lastly, women who pray with Torah scrolls. So the first part, again, the state incorporates religious rules. We actually inherited these religious rules by the Ottomans. We adopted a system called the millet system. Millet means religious community. And for many, many years, the way the Ottoman Empire operated was that although it imposed certain types of civil laws on all its citizens with respect to marriage and divorce, each religious community would determine that area in accordance with its religious rules. So the British adopted this system during the British Mandate, and then we in 1948 continued with it. Now, there's many people discussed, have wondered why we did continue with it, and there are many different reasons for it. But one person who's the head of Tel Aviv University Law School actually argues that we were just so busy setting up the country that we couldn't figure out how to change it, and we just kept going with it. And that's what we've inherited, the millet system. So the millet system, there are two major religious laws in the state of Israel that have enormous effect on its citizens. And the first one of those laws is the Rabbinic Court's Jurisdiction, Marriage, and Divorce Law of 1953. And under this law, which incorporated, again, the laws of the Ottoman Empire, which were incorporated by the British, which were then incorporated by us in this law that was passed in 1953. And according to this law, matters of marriage and divorce of Jews in Israel shall be under the exclusive jurisdiction of the rabbinical courts. And marriages and divorce of Jews shall be performed in Israel in accordance with Din Torah. That's the term, Din Torah, Jewish religious law. Now, this means that it doesn't really matter if you're religious at all. It doesn't matter if you believe in God. It doesn't matter if you're an atheist. As long as you are ethnically Jewish, you get married and divorced in accordance with Orthodox law. That means that and you have no choice about it. There is absolutely no civil marriage and divorce in Israel. Sometimes when I try and explain the situation in lectures, I sometimes ask the audience, what's the difference between a marriage that was conducted by a Reform or conservative rabbi in the state of Israel and one that was conducted in Las Vegas by an Elvis impersonator? So often someone in the audience will know the answer, and the answer to this question is that the marriage that is conducted in Las Vegas with the Elvis impersonator is recognized by the state, since it's an overseas marriage that Israel gives full faith and credit to. But the marriage that was conducted in Israel either by the conservative or the Reform rabbi is not recognized. Because, again, it has to be according to Orthodox law. We can only get married in an Orthodox fashion and divorced in an Orthodox fashion. And it's all according to Din Torah. And then there's the Chief Rabbinate Act of 1980, which states it's a rather vague law. It's a little hard to understand what it's talking about, but it has a tremendous impact, which we will see. The functions of the Council of the Chief Rabbinate are activities aimed at bringing the public closer to the values of Torah and mitzvot, and any act required for the carrying out of its function under any law. So these two major laws have a very, very big impact on the life of the citizens of the state of Israel. The result is Israel is a partial theocracy, which means, as we see here, I actually got permission from the person who did this cartoon to use it. You vote, God decides. That means that God determines a lot of what happens in this country, and God happens to speak through the rabbinic courts in the state of Israel. Anyway, so the first case that we're going to deal with is the case of the Aguna and the homosexual. But in order to understand her case, we're going to do some text studies about the issue of the Aguna. And I did send out pretty extensive text documents. And we're not going to go through all of them, but we're going to discuss a few. So the key source that I've chosen here to explain the situation of women in divorce in the state of Israel, or what I call marital captivity, which I'll explain that too in a minute, is the Talmud Bavli in Yevamot, which says, a woman is divorced in accordance with her will or against her will. A man cannot divorce his wife except of his own free will. Meaning that you can divorce a woman against her will, but you can't divorce a man against his will. A man cannot divorce his wife except of his own free will. In other words, he decides if she's married or divorced. And the term for a woman who is captured in a marriage that her husband will not release her from is the term agunot. And recently I was asked to speak in Amsterdam for a conference on marital captivity. And marital captivity is the translation that the Dutch have given to the term agunot. And I actually thought that was a wonderful translation. And they define what marital captivity means. And I've added this to this slide. Okay, it says Femmes for Freedom, which is this Dutch NGO. Marital captivity refers to a situation in which women are unable to terminate their religious marriage. This leaves women vulnerable to extortion, manipulation, and abuse. And that, I think, is a very, very good, succinct description of what it means for women who want to get divorced in the state of Israel. And in another recent lecture, I also noted that all of us are in marital captivity. All of us, that includes me. Any of us who got married in accordance with religious laws that are recognized in the state of Israel are in a situation, even if we don't want to escape our marital captivity, that is our status. So in the state of Israel, there's nothing that a woman can prove in order to get a divorce. And what I wanted to do now is show you a very, very short clip from the film Get, the Trial of Vivian Amsalem. I'd like to do that because it brings you into the religious courtroom in a very realistic way, and also because I think it's a film that's really worthwhile seeing. So we're going to just show you a minute of that film now. I'm going to try and do that, okay.
אז מה היא רוצה? גט. אתה אמסלם, היית רוצה לתת לאישה הזו גט? לא, עוד הרב. בכל מקום מתוקן, כשמי מקבל זימון לבית דין עליו להתייצב. היה שמרשתי אינה מפקר עליכם להפעיל סנקציות על הבעל. ככה החוק עומד לצידו ומעניק לו את הזכות לתת לגט או לא לתת לגט. אז יכול להיות שיגיע. אבל מה כעס לך? באנו זימן. מה עוד נוכל לעשות? את כל מה שעומד לרשותכם על לבוא או לבוא. בעולם שיכול לחייב אישה הזאת לחיות עם גבר זה. שומע אתה, היא אינה רוצה לחיות איתך.
Okay. So what we just saw in this little, very, very short clip is that Vivian keeps coming into the rabbinic court and asking for a divorce. And all that really happens there is they ask her husband if he's willing to give her the divorce, and he keeps saying no. And it keeps going on and on like that for years, until basically he finally agrees, which is not, it doesn't ruin the film, but you should really go see that. So the state abandons Jewish women to marital captivity. Even if a husband is jailed for his recalcitrance, and even if he is missing, she is in marital captivity. In other words, sometimes you'll hear the rabbinic court saying that, oh, we're doing everything that we possibly can for the woman. We've ordered the husband to give a get. We've even put him in jail. But the reality is that the situation is that this woman, that all of us, including those who want to get and those who don't want to get, we are all in marital captivity until our husbands will release us from that situation. So the case at hand that I wanted to read with you is the case of the woman, one of our clients, who was actually married to someone who is a homosexual husband, who admitted his homosexuality. She was an ultra-Orthodox woman. And one would think, because of this, because of the biblical prohibition against homosexuality, that this would actually have been a great case for the woman to have gotten all the help she possibly could have from the rabbinic court. But even in this particular case, you'll see what happens. So let's look at this together. It's text number 6 on your on the papers that were sent to you by email. But I don't know if everyone has it, but I'll read it to you. So hopefully that will be good. So in 2002, our client petitioned for divorce, and already in 2002, she noted that her husband finds sexual satisfaction among those type of questionable men. That was the way, the euphemism used to describe her husband's homosexuality. It took 4 years, in the rabbinic court, right? She filed in the rabbinic court for divorce. In 2006, the court told the husband, so again, you see, it's 4 years. It took her 4 years to get a decision, which is quite a long time. And the court hereby decides the husband is obligated to divorce his wife within 30 days. But of course, the husband ignored that decision. And in 2008, what happened was the husband decided that he was willing to give in to he was willing to certain terms for the divorce that the rabbis thought were fair. So the rabbis in 2008, after they had already ordered him to give the get, in 2008 they wrote, after reviewing the file, this rabbinic court decides that there's no room to coerce the husband to give his wife a get, and that's because he has agreed to give her 1/2 of the marital home, despite the fact that he bought it from his own money. In other words, they thought he was agreeing to what was reasonable terms. They basically retracted what was, for all intents and purposes, merely a recommendation that he give the get in 2006, and they just overturned their previous decision. And it wasn't until 2014, and as we see, it's 12 years after she first asked for a get, that the parties actually reached an agreement. And what I haven't brought to you here is our client's thank you note to us, because the reason that she actually received her get was probably because in 2010, we applied pressure on him by filing for damages in Israel's family courts, which we will see what happens in those cases too. So when Israel is placing all of its women in marital captivity, it is violating the Universal Declaration of Human Rights. Everyone has the right to life, liberty, and the security of person. So the strategy one that the Center for Women's Justice uses is to pit one arm of the state versus the other. So what we basically did when we sue recalcitrant husbands for damages in the family courts, we go from what's a religious right in a rabbinic court to a civil wrong in family court. And we construct what I call a tort of marital captivity, which is a form of false. We claim that marital captivity is a form of false imprisonment. It's duress and extortion. It's emotional abuse, and it's a violation of a woman's dignity, respect, freedom, and autonomy. And in 2001, actually, we got our first decision. That appears on your source sheet as source number 8. I won't read that to you. But in 2004, we actually got the first decision which awarded 425,000 new Israeli shekels in damages, around $150,000. And in that case, the judge articulates the mental distress and degradation that the client feels when she's in this state of helplessness and absolute dependence on her husband. So I don't think I'm going to read you the whole thing because we have two more cases that I want to get through, but you can read it. It's on the text material that I sent you, and we'll just read the beginning. The defendant placed the plaintiff in a difficult mental state of helplessness and absolute dependence on him with respect to the termination of their marital bond while entrapping her in a no-win situation. In this particular case, the husband had dragged his wife from rabbi to rabbi for 11 years, promising each time that they went to a different rabbi that he would give her a get. Each time if the rabbi told him that he had to give a get, each time the rabbi told the husband that he should give his wife a get, and each time he reneged. And that went on for 12 years, just like the other case that we spoke about. Okay, here's a list of some of the cases that were brought in different jurisdictions by the Center for Women's Justice and the different awards that we actually received for marital captivity, for the tort of marital captivity. Okay, the second case is the adulteress, the mamzer, and the man with the tattoo. Adulteress is, again, I brought you a whole bunch of sources, but the one that is really relevant for us in the state of Israel, and again, as I mentioned, Din Torah is the law of the land in the state of Israel, and according to Bavli and the Sota, just as she is forbidden to her husband, so she is forbidden to the lover, copulator, which is my translation of the Boel. As it says, is defiled. Rebbe says 2 times. It is said in the section, if she is defiled, one for the husband and one for the copulator. This refers back to a pasuk in Bamidbar, which I also brought for you, which is the case of the Sota, the woman who's suspected of adultery, and the term defiled is used 2 times, and later on in the Talmud they understand that dual use of the term defiled to refer to the fact that if a woman is suspected of adultery and she gets divorced from her husband, she can't remarry her husband and she can't remarry the person that she is suspected of having adultery with. So here I've brought to you the regulations limiting the ability of divorcing couples to marry in the future. The state restricts the ability of divorcees to marry if suspected of adultery. In other words, if the state suspects, because the husband suspects, right? If the husband suspects that his wife may have had an affair with someone and he tells the rabbis about that, they will actually subject her to a sex trial to determine if who she was having sex with and if she actually did have sex with him. And even before they conduct such trial, they will put her on a blacklist as someone suspected of having had adultery and therefore cannot marry her lover if she goes to the court and asks for a license to marry. Nursing mothers, you'll understand why I brought all these together, because it all relates to the story of the woman, the mamzer, and the man with the tattoo. But another Din Torah rule is that if you're nursing, you're not allowed to get married for 24 months. and she can't marry another man if she is nursing another man's child. In other words, if she got divorced and the child is her ex-husband's, she cannot remarry for 20 months because according to the Din Torah rules, the milk belongs to the ex-husband, and the halacha, the Din Torah rule, is worried somehow that she will compromise the rights of her ex-husband, and her ex-husband's child was also her child, to that milk. And so actually we have regulations and directives regarding registration for marriage from 2013 that a woman who is nursing has to get special permission of the Rabbinic court to remarry. And this was something that I actually didn't know. It was a new rule for me. And when the client came to us with the protocol of the Rabbinic courts, this is how it read. And I actually gave you on your source sheet quite a bigger section of this protocol. And I'm going to read it to you because I think it's really quite astounding. Court, do you live with your partner? Petitioner, yes, we were waiting for a marriage permit. We've been living together for 4 months. I stopped breastfeeding 2 months ago. Do you have milk? No, I do not. I stopped breastfeeding and also initially had a problem with breastfeeding. I tried to use a breast pump but was not successful. Did you take drugs to stop the milk? No. Are you going out with other men today? Of course not. I love him. I do not want anything else but to be with him. So you're probably wondering what all of this is about, but what I really want you to notice in particular from this protocol is the involvement of the court with this client's breasts and her milk, which, as I'm sure you're aware, is a tremendous invasion of her privacy. And then the mamzer.
Susan, can we ask 2 questions about that just while you're there?
Yes.
So one question from Stephanie Wolf is about the previous question about if the woman can sue in civil court for money in lieu of the divorce.
Yes.
The answer is yes.
Well, it's not in lieu of the divorce. The idea is that the not giving her divorce causes her harm. It causes her mental anguish and grief. So even if the husband gives her a divorce immediately after she sues, she's still entitled to damages. She's still entitled to compensation for the grief that she suffered for not having whatever time it was.
Okay. Rob, can you try mute? Welcome. Thanks. And then the second.
Is that sufficient answer to that question?
Yeah, and then the second question was just about the previous text. The question is, if the ex-husband is deceased, would that still apply?
That's a good question. I have a feeling that it would not, but I don't know the answer to that question. It was such an unusual case for me, and trying to understand the logic was hard enough. But I think that she would probably be given permission more quickly under those circumstances, but I don't really know. But let's go to the mamzer, and then we'll all of these points will come together, I hope. Mamzer, lo yavo mamzer b'kal Hashem, gam dor asiri lo yavo lo b'kal. And the prohibition or the rules of the child born of illicit unions is learned from Deuteronomy 23:3, but it's not so. It actually isn't so intuitive from the biblical text, but it is the source from which the Shulchan Aruch and the Rambam learn that, and this is source number 17 on your list. What is a mamzer? Is a product of a union that is called arayot, whether it is a capital offense or one punishable by spiritual death. In other words, all of the illicit relationships enumerated in Vayikra can result in a mamzer in the state of Israel. So, and the key mamzer that is usually looked for in the state, although it's not the only mamzer situation, is the child born to a woman from her relationship with a man who is not, while she's married to her husband. In other words, a man who's not her husband while she's still married. So the state has many, many laws and regulations with respect to this, and I'm going to go through them pretty quickly, and then we'll go to the actual case. So the state targets mamzer at birth, preventing the mamzer from knowing who his or her father is. The Israeli Population Registry won't let a woman register her child under the name of a man who is not her husband. In other words, a divorcee, someone who is divorced, must register a child born within 10 months of that divorce under the name of her ex-husband. Okay, I'll explain that a little bit more. It keeps a blacklist regarding the mamzer status of babies. The Attorney General has issued regulations or directives saying that the Rabbinic Court's jurisdiction law, that's the law that we saw in the very beginning, which states that marriage and divorce of Jews will take place according to Torah law. From hence, we derive the authority of the rabbis to register the marriage, to oversee the marriage ceremony, and to issue a marriage certificate. The registrar need not suffice with the declaration of the couple that they have capacity to marry each other, but is authorized to examine and check. Once he's authorized to examine and check, if he examined and checked and found out that there's a problem with the marriage, he can put them on what we call a blacklist, and is literally a blacklist. It can also conduct trials. Should a woman come before them asking for divorce and she's pregnant and they wonder about who the father of the child is, they can order the opening of a separate file to investigate the issue. So here's what happened in the case at hand. Our client went to get a license. She was a divorcee. She went to get a license to marry. She wanted to get a license to marry, and she was nursing a child that was born approximately 8 months after her divorce. And when she came to get her license to marry, so first she was subjected to that cross-examination that we read before about her milk supply, and it was at that point that the court was worried about who exactly the father of this child was. So in accordance with the rules and regulations that you just saw, they actually transferred her, they opened up a separate file for her and her child in order to examine who to conduct what is equivalent to a sex trial, and to examine who the father of this child was. And so here in text number 22 is part of the protocol of that trial. And then you'll understand what this man with the tattoo, why I call it the mamzer, the nursing mother, and the man with the tattoo. The court, were you together after the separation? And this is referring to the mother and her ex-husband, the woman. We broke up in October 2010, and the child was born in November 2011. And when she broke up, she means she wasn't living with him anymore, not that she actually had her get. I have not found out the identity of the man who were with me at the club. There were a few. I know one was circumcised and the other had a tattoo with a cross. They were Russians, but I have no information about them and I cannot find them. Even if I see them, I would not recognize them. It was a one-time thing. When were you with your husband for the last time? Woman, it's hard for me to say, maybe in June or July 2010. Did you have sexual intercourse after your divorce? I did. I learned I was pregnant only after the divorce. After I found out I was pregnant, I was with someone a week and a half after the get. I had sex with someone once. Mr., her ex-husband, appeared. Both my mother and father are Jews. In October 2010, I severed all connections and we did not have sexual relations even a few months beforehand. In other words, what the court is trying to establish here is if the ex-husband is the father of this child, because then the child would not be a mamzer, and it would go in accordance with the rule that it's assumed that most cohabitation is with the husband, and that therefore the child was the child of the ex-husband. But here, the husband specifically said that he did not have the ex-husband specifically said he did not have sexual relations with his wife, and she also made the same claim. And what she is trying to establish with her other testimony is, in fact, that the father of the child is someone that she had sex with when she went to a club, and that it was probably a non-Jew, and therefore the father of this child, whose identity she doesn't know, and is not a Jewish person, and therefore if the father is not Jewish, then in fact the child is not a mamzer according to Jewish law. But the reason I brought the protocol for you is to just show you what this poor woman had to go through in front of the rabbinic courts in order to try and figure out how to make her child kosher. She came to us at the point where she was already had this decision from the rabbinic court putting her child on the blacklist. And what we did was we appealed to the high rabbinic court. In the high rabbinic court, I told the rabbis that it could also be assumed that this child was born 8 months after he was conceived, she was conceived, and therefore was not a mamzer under any, irrespective of who the father was. The rabbinic court asked to see her medical records to establish whether or not that could be true. In other words, whether she actually did give birth after 8 months. I told the court that they had no right to ask for her medical records. And when the rabbinic court refused to hear that argument, we went to the Supreme Court. And the Supreme Court barred the rabbinic court from getting her medical records. And at that point, we also argued that the child should be taken off the blacklist because the child did not come to marry and divorce. And I will get into that in a second. I just wanted to show you this slide, which is a slide. We actually asked the rabbinic court how many people were on the blacklist and why they were on the blacklist. And this is some of the information that we got. And as you can see, there were 94 mamzerim on the blacklist in 2008. In 2014, there were 235. There are actually a lot more than this number, but that's just something I wanted you to see. It's obvious that all of the trial and the protocol that we just read, that it's a severe infringement on the privacy of our clients.
Susan, can we ask a few questions about that, actually?
Yeah.
A lot of good, excellent questions coming in about this case and the case in general. The first is just, this astounding notion of the blacklists that have been established. First of all, have you seen them? This is coming from Neil. Go ahead. Have you seen them at all? And is there any way to sort of some sort of Freedom of Information Act or rule or something that they can be accessed to know? And then, of course, what happens if you're on the blacklist, and how do you get off of the blacklist then? And then there's a few more questions after that.
Okay, it's the blacklist. The blacklist, the state, and the Rabbinic being an arm of the state, has a very equivocal relationship with the blacklist, because on one hand, they intrinsically know that this is not a good thing. And so they keep it very close to their heart. And what they try and claim is that no one can see the blacklist except for very few people. Nobody really knows that they're on the blacklist until they come to marry or divorce. That was a few of our clients. And sometimes if a client suspects that she's or he is on the blacklist, we will ask, the court, the rabbinate, to tell us if they are on the blacklist. But theoretically, the blacklist is only supposedly available to one or two people in the rabbinate. And when a marriage registrar, when someone comes to the marriage registrar, they call up that one person and ask them if the person is on the blacklist. We solved this case for the woman, the nursing mother with the husband, with the man with the tattoo. We actually, we did do that, and I'll tell you how we did that. But we have quite a number of mamzer cases in the office. We've solved all of them to date. In one case, we had a client whose mother, we established, got married in a civil ceremony, and therefore not in accordance with Kedat Moshe Israel. We got him off the list. He found out he was on the list when he went to get married. And you can imagine the distress that he was put under when he found out, and how he had to tell his bride or not tell his bride, and how long. And it took us months to resolve the case. It was nerve-wracking for him, for sure. But we did resolve the case, and we had another one that we resolved. But in this case, we also petitioned. In the case of the woman with the man with the tattoo and the nursing mother, we asked the Supreme Court to throw out all the children on the blacklist, including our client, because we argued that giving the Rabbinic Court's jurisdiction on marriage and divorce doesn't give them jurisdiction on someone who didn't come to get married and divorced. And since a child, by definition, hasn't come to get married and divorced, they should not be on the blacklist. So this, I think, is an excellent argument. And the Rabbinic courts did not want this decided in the Supreme Court. So with that pressure and the decision of the Supreme Court preventing them from actually getting the medical records of our clients, the Rabbinic court actually decided that there was a good chance that the father of this child was a non-Jew, and took the kid off the blacklist.
Yeah, thank you. And can you clarify also just about mamzerut status? And first of all, what happens once one is labeled a mamzer? Can they then marry? And then there's a particular question about that if, for instance, if a husband cannot have children and a couple uses IVF,
right,
that child automatically deemed a mamzer, or do they then need to prove that the father was infertile?
Those are two really, really good questions. Okay, I'm sorry. Sometimes I give lectures and I take some of these things for granted that you know. A mamzer cannot marry another mamzer. I mean, cannot marry a kosher. He or she can only marry another mamzer. And actually, there's another status called safek mamzer. They're not sure if you're a mamzer, and that's even worse because you can't marry a mamzer and you can't marry a kosher Jew. So, as I explained, this one client that we had went to get married, and when they found out that that he was on the blacklist because his mother had gone to get divorced like 30 years before that and was pregnant with him, and told the Rabbinic court that the child was not her husband's at the time because she really wanted to get, and the husband wasn't giving it to her, and he was put on the blacklist at that time. With respect to, what was it, the second question again was? About the
case where a husband was using IVF.
IVF.
Or the family was using IVF.
Moshe Feinstein decided that if you got, an IVF situation is not a situation that results in mamzer. In fact, one of the women who works with us, Rivka Lubitch, often uses that as one of the solutions to the whole mamzer problem, which is something that we're really working on now, because if we all could have been born from in vitro fertilization. So if we were all, maybe we were all, not conceived in the biological way, and maybe we were all from IVF. So therefore, we're all should be not mamzerim under that fiction, let's say. But no, that is not a mamzer. And in fact, although I say it like that, it's not so clear, because in fact, many women now who have had children within, either as single parents or, from sperm donations or in vitro fertilization, are now finding themselves going to the rabbinic court to get their imprimatur that the child is not a mamzer. So although Rav Moshe did decide in that manner, it's not so clear that all of the rabbis in the rabbinic courts in Israel will hold that way. So anyway, so the second strategy that we have is strict scrutiny of the law. In other words, we want to interpret the law narrowly, and that's what we tried to do in this mamzer case. We said that the rabbinic court's jurisdiction over marriage and divorce law has to, is only over marriage and divorce, and not children, right, who have not asked to marry and divorce. So it's a matter of interpreting the law narrowly to prevent infringements on human rights.
Yeah, and on that, just one last question. This is asked, in all seriousness, is there some sort of mechanism in Israel or a service that would match people who both have, potential couples with mamzer status?
No. The people who are mamzerim, many people in Israel will tell you there's no such thing as a mamzer. We don't know any mamzerim. In the Center for Women's Justice, we know many, because we are the only NGO dealing with it. But as soon as someone knows that they have that status, they try and eliminate it. There's no dating services for that. It's a giant taboo. No one wants to be considered a mamzer. I'm going to go. I would like to go women who pray with Torah scrolls and do that pretty quickly for you, because I want to get to my conclusion, and I still want to leave a couple of minutes for some questions. So this is not in the area of marriage and divorce. It's also a case of ours, and I'm sure you're more familiar with this. And this falls under the rubric of the Rabbinic, which is the second major law that of religious law in the state of Israel. Anyway, protection of holy places of 1967. Holy places shall be protected from desecration and other violation. The regulations that were passed in 1981, you might be familiar with this. Regulations are not laws, okay? They are easier to pass. They are what's called secondary laws, and they're usually passed by an executive body. So the following are prohibited in the areas of the holy places: conducting a religious ceremony that is not in accordance with local custom. And as you see, Section 4 of these regulations say that the commissioner can consult with the chief rabbis of Israel to determine really what is the religious ceremony that is in accordance with local custom. And then in 2010, the commissioner of the wall passed express guidelines saying that women could not pray with Torah scrolls in the wall. And we brought a lawsuit, and this is our strategy number 3, prohibiting regulatory overreach. In other words, what we argue is that the protection of the holy places laws, the protection of holy places laws of 1967 does not allow you to infringe on the human rights of people who want to come to pray. So here's how we argued it. The regulations are outside the boundaries and its objections. This is from our actual petition to the High Court of Justice. The goal of the law of the protection of holy places is to secure the rights of individuals to freedom of religion and not to compromise those rights. Its aims and objectives were to cement the status of the different religious communities to the holy places that were now under the sovereignty of the state of Israel. In other words, the law was meant to allow people to have access to the holy places. It wasn't meant to prevent people from having, and people including women, from having access to those holy places. So that is pending. So then I'm going to go to my conclusions, because I would like to really open it up. But, and I'm quoting here on purpose from a woman who is a Muslim feminist. And here's where this is from an article in which she discusses the possibility of interpretation. Because I'm sure as Reform rabbis, you know that, or one of the mechanisms that you use to make sure that our holy laws are updated is reinterpretation. So one could argue that, well, what's the problem of religion and state in Israel if we have rabbis who can reinterpret and make sure that our laws are up to date? Let's put it that way. So let's see what she says about that, because that's what some of the Islamic feminists say. They say, well, you know, really the Quran is about peace and it's about justice. So she says, I'm sympathetic to the discursive strategy of these Islamic feminists, but I am concerned about the focus on the correct reading of the Islamic text. A reasonable concern is that so long as Islamic feminists remain focused on theological arguments rather than socioeconomic and political questions, and so long as their point of reference is the Quran rather than universal standards, their impact will be limited at best. At worst, their strategy could reinforce the legitimacy of the Islamic system, help to reproduce it, and undermine secular alternatives, which is what I think you're seeing happening in Israel. So my conclusion is you need to separate church and state in Israel for the sake of agunot, adulteresses, mamzerim, women who want to pray with Torah scrolls, all of us, and for the sake of the halakha. In other words, it is really my feeling that we need the private sector to be able to provide different interpretations of religious law. We cannot leave it in the hands of clerics of any ilk or sort, and the state must protect the human rights of its citizens. And the issues of privacy and issues of liberty cannot be in any way compromised. And you know, today we may have one day we might have liberal rabbis who would interpret the halakha in accordance with universal standards, and tomorrow we may have rabbis who do not, as we have today actually. So it's really my feeling that the American model is the correct one, and we cannot allow the abuses that we've seen here to occur in the Jewish and democratic state of Israel. Anyway, we have a couple of minutes left for questions, so can we open
Great,
it?
thank you so much. I'll read some of the questions that are coming off, but I think that we're a small enough group that actually if people want to unmute and turn on your cameras to raise your hand, I think that's totally fine. We have about 6.5 minutes left. So a couple of questions that have come in. Which body or bodies oversee marriages and divorces of people who are not Jewish? So other religions in the state of Israel, just to clarify on that point.
Okay. If there are two Muslims, Sharia law is determinative and there are Muslim courts. If you're Catholic, canon law is determinative and there are canonical courts. To the best of my knowledge, Druze courts, we have 15 recognized millets in the state of Israel. But if you're a mixed marriage, then your case will go to the family court. But first, actually, it's quite a complicated process. First, it has to go to each spouse's respective millet, and that millet has to declare what they think is the status of this particular marriage, and then it goes to the family court to dissolve the marriage, most of the time by agreement. I've actually never had a case of a contested marriage of persons of different religious persuasions.
I think that also goes to speak, if I may, to the notion of if we're pushing for freedom of religion, we're also pushing on freedom from religion, which would allow that kind of thing to happen. This is another just sort of a organizational question about what is your relationship with our Reform Movement institution of Iraq, and the work that's being done together in the course with Orly Arzakowski and Anat.
I have a very close relationship with Orly, and you know, I call her up on the phone, she calls me up on the phone, and sometimes I even front for the reform movement in the sense that sometimes some of our cases that we brought, Orly thought it would be better that I bring it than it be brought by the reform movement. So we have a very good working relationship.
That's great.
You know, they know everything that's happening in the case of the Torah Scrolls case, and they're right there. They're right there with us.
Yeah. Just to clarify on the question of the Jewish, non-Jewish, Karen, maybe you want to just clarify if you can, if you're able to unmute.
What do you mean Jewish? Are you asking me?
No, I was asking Karen Company. So just to clarify, she had a question about the notion of the family court. You know, someone who is not Jewish. Okay, if you're not able to unmute, that's okay. Susan, let me ask you just sort of a general question. Oh, Karen, are you there?
Yeah. So somebody who's not Orthodox, are they considered Jewish by the Orthodox courts in Israel?
There's a convert, a reform and conservative convert would probably not be considered Jewish by the Orthodox court. But that's also an overstatement. I actually could have used the converts as the third case study here, but that is a whole other lecture. But Reform Jews, conservative Jews, atheist Jews, agnostic Jews, Jews for Jesus are all Jews according to the Orthodox, as long as they're ethnically and racially Jewish, they're Jewish. Doesn't matter who they believe in.
Thank you.
So, Susan, just maybe to sum up the question, then I want to turn it over to Rob Nozenchuk to conclude the call. If you're, you can go back on mute just for a second. If you're a general, I know you're not a prophet, but what do you see happening? Do you see any real change happening in this anytime soon? I feel like this is a big pressure cooker. This is something that I think about daily, and that many of us obviously very concerned about. Do you see any formidable steps, whether it's in society at large or within the rabbinate, to make any significant changes here in the near future?
The place where I really see significant change is in society at large. In other words, I think that change is coming from the grassroots. More and more people, more and more of the modern Orthodox are saying that the king is naked. Many young couples are choosing not to marry in accordance with rabbinate. One of the phenomenons that I see, and it's quite unusual, I think, is that there are Orthodox young couples who don't want to marry with the rabbinate and still want to get married in an Orthodox ceremony. So that's also, I think, quite astounding. But I didn't really understand it at first, but I'm beginning to understand these couples more, because what they just don't want to have anything to do with rabbinate. And all of this is causing quite a stir. And I think that's how the change is really happening, and also from the nonprofits like us who are constantly saying that the king is naked, and eventually and everything that's happening around the Western Wall, I think, is tension that has to lead to some sort of change.
Great. Thank you so much. I'd like to turn it over to Rabbi Rob Nozenchuk, who's our co-chair of the ARZA-Rabbinic Council, to conclude the call. And thank you.
Can you all hear me? Well, I just want to say thank you on behalf of the ARZA-Rabbinic Council and the Women's Rabbinic Network to Sue.
I think you froze there, Rob.
Yeah.
We'll give him a second.
Okay.
what we want to say here is that we're very appreciative of you, Susan, for taking your time and joining us and sharing of your great wealth of knowledge. I do want to recommend to all of you Susan's book, Marriage and Divorce in the State of Israel. Very important read, and reads like a novel. I mean, it's
I keep
Robin,
losing.
okay, there you are again.
Did I lose you? You're just going to hear me voice-wise. The Rabbinic Cabinet produces programs like these, and we really invite anybody who's just joining to see what this is all about to join the Rabbinic Cabinet. Go to ARZA.org or be in touch directly with Josh Weinberg, with Neil Gold, with Judy Schindler, or myself. Judy and I are co-chairing the Rabbinic Cabinet. We really want it to grow. Speaking of, in just a couple of weeks, 2 weeks from now, the Rabbinic Council will gather again for a webinar, this time with Rabbi Dalia Marks from Hebrew Union College in Jerusalem, Thursday, March 30th at 1:30 p.m. Eastern. Dalia is an editor of the New Israeli Reform Haggadah, and she'll be teaching us about the radical Haggadot that the 20th century Zionist pioneers created in response to the new era of Jewish history, and how our colleagues have integrated some of those Zionist innovations into their new Haggadah. There'll be lots of Chomer LaDrush for Pesach here. Finally, just note that ARZA's new curriculum about the 50th year anniversary of the Six-Day War is now available. You can be in touch with the ARZA office. Again, thank you to everyone for participating today. What a remarkable day we've had, and I'm looking forward to studying up on these texts further. Lehitraot, everyone.
Exactly. And for those of you who will be at the CCAR next week, I hope to see you.
All right. Thank you very much again for inviting me. Bye-bye.
Thank you, Susan.
Pleasure.
Okay. Toda rabba, Shabbat Shalom.
Shabbat Shalom. Close enough. Close enough.
Close enough. Yeah.